Go. Happy Wednesday, everybody. My name is Aaron Conant. I'm the co-founder, managing director here at BWG Connect. We're a giant networking knowledge sharing group of digital executives. I spend the majority of my time talking to organizations around their biggest pain points, strategies, networking knowledge sharing across the board. And from those conversations, we get the topics for events that are most relevant. We're going to do somewhere around 250, 300 webinars this year. We're going to do 100 in-person events. Would love to meet anybody in person if you're in a tier 1 city, all focused in the digital space and all really relevant. The other thing is in these conversations, we're also asking, the brands, who's working for you and who's not. And that's how we get a short list of the experts that we bring in to host and moderate these events with us. And so if anybody ever has any questions anywhere in the digital landscape for a short list of, hey, best providers on anything from Amazon, direct to consumer, obviously brand control, international expansion, drop shipping, whatever it might be, don't hesitate to shoot me an email, Aaron, AARON at bwgconnect.com. That's what I spend the majority of my days doing, is helping people with partner selection. Housekeeping items. We started this 3 to 4 minutes after the hour, and just so everybody knows, we're going to wrap up with at least 3 to 4 minutes ago as well, and give you plenty of time to get on to your next meeting without being late. And I think with that, we'll kind of jump into the topic today: new ways to protect your brand through IP and design patents. So this is just an interesting topic. We got connected with the team over at Vorys eControl probably 6 years ago now, because brands had a major issue around protecting their brand, and it's only grown. I would have thought after 6 years we'd started to tackle it, and while we have, it keeps evolving like anything else, and so it's gotten harder and harder. And so we do a lot with the team here at Vorys. They're great partners, supporters of the network across the board, and so thanks to you guys for jumping on and sharing today. But Martha, I'll kick it over to you. If you want to do a brief intro on Vorys eControl and yourself, that would be awesome. And then you can kick it to Emma and Aaron for their intros as well. And then we'll kind of start in the conversation. Sound good?
Yeah, sounds like a plan. Well, thanks everyone for joining. My name is Martha Motely. I am in the Columbus office of the Vorys law firm. We are a firm that was started in 1909. So we are a full service law firm, and we happen to have this really cool eControl practice in addition to being full service. So I manage our litigation specific to our eControl clients. And I have the pleasure of working with Emma. Emma, do you want to introduce yourself?
Yes. Hi. Thanks, Martha. Emma Morehart. I'm an associate. I focus on our eControl litigation. I've been doing exclusively eControl litigation for about 5 years now in our Cincinnati office.
And Aaron?
Sure. Yeah, I'm Aaron Williams. I'm a partner with the Vorys law firm here in our Cleveland office. I do all forms of intellectual property litigation. So work with our eControl team, as well as handle traditional trademark, patent, trade secret, trade dress cases all across the United States.
Awesome. So a quick reminder, we always like these to be as educational and informational as possible. So at any point in time, if you have questions, drop them real time into the chat or into the Q&A, or you can always email me, Aaron, AARON at bwgconnect.com, and we'll be sure to get those answered pretty much real time if we can. So drop questions as we go. Yeah, let's jump into it. Like, it's a cool topic. So let's jump into it.
Yeah, definitely. All right. So Emma is driving our slides for us today. So Emma, next, please. Okay, so high level, just a couple thoughts about our eControl program, because a lot of folks haven't heard about eControl, and candidly, eControl is a word that we made up. So I would fully understand if you did not know what this eControl thing is all about. Just sort of high level, it's a comprehensive solution that's intended to help remove unauthorized sellers from the platforms, to assist with MAP compliance in the US and Canada, to help control and grow online marketplace sales, to stop product diversion, and to eliminate channel conflict. And we do that through a series of sort of legal policies and strategies that we combine with our business knowledge to make sure that we have sort of this full front to back solution so that we can help brands go after the bad guys who are impacting their profitability, and more importantly, and perhaps most importantly, making sure that consumers have a great consumer experience, and so that the brand's reputation is well protected on the internet. So that's kind of high level what we do. We represent a ton of brands. If you were to open your medicine cabinet, we represent them. If you open up your garage, we represent them. Anything that you eat, touch, put on your skin, comb through your hair, we probably represent them too. So a lot of brands, a lot of good experience, a lot of good cross market experience. And it's not just Amazon, it's eBay, it's the next one and the next one, and whatever the next great one is, I'm sure we're going to be dealing with that too. We have a massive center down in our Cincinnati office that helps us send out enforcement letters. So we've sent out over 60,000, and I honestly think that that number is quite low. I think it's significantly higher. So it's a big machine, and we are part of that machine, and we are specifically the litigation piece of that. So Emma, if you'll slip to the next slide, please. So we are talking about litigation strategy here today. I took a peek at our guest list, and it looks like most folks are non-lawyers. So we are going to try to cool it on the legal jargon. If I start to get too jargony, or you don't understand what I'm saying, or Emma or Aaron, please just pop us a note, because we do tend to slip back into those legal terms and phrases that can be nearly incomprehensible. So we're going to try to talk about this in sort of high level regular terms. There's certain things that we would love to answer, but we can't, because we do have certain ethical obligations to not divulge client information, which I'm sure those of you who are clients very much appreciate. So we're looking at this umbrella, and underneath this umbrella is all of the litigation that we handle. So primarily what Emma and I are dealing with on a day-to-day would be this little light blue box that is the unauthorized seller lawsuits. So this would be the folks who are on Amazon or eBay who are simply not authorized to sell your products. We've initiated something like 300 litigations, I think, Emma, against folks who are in pretty much every jurisdiction where you can file a federal lawsuit. Okay, so that's one piece of it. We're not talking about that today. We also manage ADA website compliance litigation. So those are, you've probably all gotten predatory letters from folks who say, hey, your website isn't reader friendly. It doesn't have the appropriate e-readers set up so that folks who are visually impaired can access it. We handle those too. What I want to talk about today is a sort of a flip on how you generally think about litigation. I think when you go to brands and you talk about litigating, they're thinking about it being on the defensive side, right? So what happens when somebody sues us, sues the brand? And we do a lot of that defense work, but again, that's not what we're talking about today. We're not talking about you are in the crosshairs of a predatory plaintiff's counsel. What we're talking about is a way that we can make litigation less risky, cost effective, and very successful in terms of protecting your brands online. And specifically, we'll be talking about counterfeit litigation, and Emma will talk about that. And then Aaron will talk about trademark and patent lawsuits. So it requires us all to flip our thinking just a little bit and cross over to the other side and think about what is it like to be the one who's actually going into the litigation willingly, as opposed to what we sometimes see on the defensive side, which is people have been dragged in kicking and screaming. Emma, to the next slide, please.
We're really quick on the ADA side.
Yeah.
If they get hit with letters, they just email you, like?
Yeah.
Okay.
Yes, you can email me. I can get that to the right person. We have a gentleman on our team who deals with these folks day
Because
in,
everybody gets
day
hit with
out.
it, right?
I
And
know. And
Yeah.
it's really offensive, because those laws are good and important and have an important purpose, and they've just been so twisted so that these plaintiffs' counsel go out, and really what they want is a settlement, and the settlements are between 10 to 50 to 100, depending on who the plaintiff's counsel is, and we know all these guys. And it's, it really is predatory. So yes, if you get one of those letters, don't panic, just call us. Thank you, Aaron, for that.
Yeah.
Yeah. So we're talking about what to do when you want to file a lawsuit, and we're going to talk about the strategy here. And to sort of set the table, the scenario that you would be dealing with would be either a true counterfeiter, where you have reason to believe that someone is online and they're selling a product that is a not genuine product, that it hasn't come out of the appropriate manufacturing facility, it hasn't been made in your according to your specifications, it is not simply unauthorized or intended for Europe or LATAM. It's actually a counterfeit product. So that's sort of one bucket that Emma will talk about. And then the other bucket that Aaron will talk about is when you see somebody online who's basically knocking off your IP. So it's kind of a knockoff would be the way I think most people would think about it. And what I'm going to talk about is the strategy that generally applies to both of these scenarios. And Emma and Aaron can talk about the slight differences. So what we want to do first, and we know this because we sometimes get pulled in after the fact when folks have hired someone else and when we get asked to come in and help, clean up some of that mess, or we get brought in once a brand has gotten halfway down the path and realizes, gosh, I'm not really sure what to do in what order. So we want to head that off the path. We want to make sure that we're coming into these both scenarios, both this true counterfeit and this design infringement arena. We want to make sure we're coming in with a plan. Okay, so we want to work with the brand to engage in strategic test buys to set a baseline for the genuine product, or what the challenges are between the genuine product and the knockoff product, right? So we want to make sure that we are being very organized in terms of who is doing the product buys, where are they physically located, where are they requiring the product buys to go, because once we get down the road, we may want to have made product buys into certain states to help us with that litigation. So again, trying to stay away from legal jargon, but there's a legal concept called personal jurisdiction, which is where the court looks and they say, hey, is it fair for this defendant, this bad guy, to be sued in this state? What's their connection to this state? And one of the ways that you can ensure that that is appropriate is by doing test buys into that state. So we'll work with the team to make sure we understand where's everyone located and where do we need to be doing the test buys. We also see a lot of scattershot test buys across the enterprise where folks are not carefully organizing who has done what, what's the order number, what was the result, where did it come from, when was it received. We need all of our ducks to be in a row. We've seen it go really, really well and have recommendations on that. We've seen it go really, really poorly and have recommendations on how to avoid that. We can also assist the brand in identifying what the counterfeit is and explaining in a comprehensible but also legally defensible way what are the differences. So on the one hand, we want to make sure that we're giving the appropriate entities enough information to know, how do we know this is counterfeit? How do we know this is a knockoff? Contrasted with, we want to make sure we're not giving the bad guys so much information that they know, aha, the key here is that Singapore has been spelled incorrectly, and I'm going to fix that on the go forward. Or the key here is that the strike marks or the mold or injection marks are not in the appropriate spot, and I'm going to fix that on the go forward. So part of our investigation plan is getting all of those pieces together so that we know the who, what, when, where, and can explain that to the appropriate entity, whether it's Amazon or the court, in a way that is clear, cohesive, makes sense, and doesn't spill all of our secrets.
Yeah, I mean, it's also, from the claiming counterfeit, this is another reason not to do it right away, right? Because I know, in some instances, a brand goes out and claims, hey, it's counterfeit, and then they find out it's not. And then if Amazon has shut down that storefront, then that seller comes back, right, for claims on lost profits.
Yeah.
But here's another reason not to do that. And I don't know if you want to expand on that a little bit, because you guys have probably dealt with it. I hear it from brands and how it really went sideways, but this is another reason not to do it, because you're going to ruin your potential test buys, right?
Yes, 10 million% to all of that. I'll let Emma talk a little bit more about what we've seen in terms of those litigations, but yes, it is real. It's scary. I was just dealing with one yesterday, and I think I have another one popping up where somebody who is well-intentioned at the brand made a counterfeit complaint, and it turns out it wasn't counterfeit. And turns out Amazon actually does care about whether something's counterfeit, and that can create all sorts of bad issues. So yes, Aaron, you're absolutely right. Those are significant risks.
Yeah. Because I mean, that was the common thing, right? Oh, just claim counterfeit and they'll shut it down.
Yes, please don't do that.
Yeah, don't do that. Yeah.
If there's one thing you take away from this, please don't do that. Please don't just yell counterfeit into the void, because although Amazon and the other platforms as well do feel a lot like screaming into the void. You know, they sometimes hear little words here and there, and counterfeit is one that they do hear.
Awesome.
All right. If anyone has questions about any of this, again, pop into the chat, and happy to answer as we go.
We have just one right now about a GS1 certificate due to a company name change, but maybe we can tackle that one towards the end, or there's a
Yeah.
follow-up.
I think we can probably tackle that that sounds like an Aaron question. Yeah, Emma, maybe the next slide. Okay, so to orient us in space and time, we have done all of our initial steps where we have done our test buys, we have confirmed, we have validated it is truly a knockoff or a counterfeit. We have our ducks in a row, everything's organized, it looks beautiful. We're ready to go. We're ready for litigation. Okay, so what does litigation look like? It looks like a who, what, when, where. Okay, so who are we going to sue? We want to make sure that we have identified the appropriate person. I've seen person or entity. I've seen far too many litigations where a well-meaning but perhaps uninformed lawyer will initiate a lawsuit against the entity or the person who is listed on the Amazon storefront, when in reality we know that those are not scrupulously accurate, and sometimes they are intentionally misleading. I could probably do a full webinar on the scenarios where we've seen fake, falsified, fraudulent information listed on Amazon. So it's all well and good to do your test buys, but when it comes to filing the litigation, if you don't know who you're suing or you're suing the wrong entity, it's really going to slow things down, and the court will sometimes let you, depending on the timing, update your case, but sometimes you've got to ask the court for special permission to do that, depending on where you are in the sequence. So it's really important that we do that work at the front end to make sure that we know who these entities are. And they're tricky, and they hide under rocks, and we know where those rocks are, and we know how to get the snakes to come out from underneath the rocks, so to speak. We have a very robust team. One particular investigator who can find anyone. I offer her services for litigation as well as ex-boyfriend reconnaissance. So she can really do it all. She knows how to find people, and she knows how to find where they're physically located so that we can make sure that we're getting the right people pulled in the first time, because we don't want to have to do it more than once. So then this is sort of the scary part that brands kind of hold their breath and say, are we really doing this? Yes, we're really doing this. It feels scary. It's not that scary. We are going to file a complaint, and we're going to seek a temporary restraining order. I'm delving into legal jargon a little bit, but bear with me for a second. So the complaint, most of you know, is just the written legal papers where the law firm sets out, here's what has happened and here's why it's bad. We put it into legal jargon, and then we try to make it easy for you to read by just calling out what we need you to validate. The temporary restraining order. So we do this on kind of a secret basis. It's called ex parte, which means we can go to the court before we let the bad guys know what we're doing. And the element of surprise is key here, because we don't want them to find out, hey, we know who you are, we're on to you. And then what do? Of course, they just create a new storefront and they move their things over, and they go on, and we have to do another test buy, and we have to do another validation process, and then they get wind of it, and then they move on to the next storefront. We want to avoid that. So there's a process called ex parte, which means without the other party's involvement, where we can ask the court, hey, Your Honor, you need to let us do this complaint secretly for right now, because we don't want to tip off the bad guys so that they do these things in response, like move their assets, move their product out of FBA, shift over to another storefront. Now, at some point, we will have to let them know about the litigation, but we need the element of surprise, and we need the court to grant that temporary restraining order, which only lasts for a couple weeks or a couple months at the most, so that we can take that court order and take it to Amazon and say, hey, Amazon, the court has said as a preliminary matter, we are right. We've given the court enough information to think that we are going to win this, and you need to freeze everything. You need to just put everything on hold. It's not an adverse event against the brand at this point. I'm sorry, against the bad guys at this point. It's just holding everything. It's like pushing the pause button so that they can't move their assets out of Amazon and they can't move their inventory out of FBA. And by doing that, we put the pressure on the bad guys, because now their assets are frozen and their inventory and FBA is frozen, and they don't have the ability at this point to shift it over to another storefront, requiring us to start the whole process all over again. So the
So
element of Yes.
Amazon is cool with this? Like, I mean, do they have to? Is it one of those obligation things
Yes.
because it's a court order
Yes,
that they
it is.
can't say no?
Yes. Are they cool with it? Questionable. Do they have to comply with court orders? They do have to comply with court orders. There's a whole team set up, and the team is very kind and they're very responsive, which is not the case for all of the Amazon various workflows. But the TRO team is specially trained to review these legal pleadings, and they know what they've got to do to push the right buttons. So
So this doesn't go to your vendor manager. This doesn't go to somebody,
Nope.
a seller central. This
Nope.
is completely different because it's just going to go to the recycle bin for them.
That's exactly right. Yes, if you send it to the brand registry person, please we don't want them to then tip off the bad guys, because typically what happens when you make a brand registry report is that it kicks out the emails out to the bad guys, and that tips the bad guys off, hey, there's a counterfeit. So in the short term, it probably gets that one storefront taken down, but that bad guy who is scrupulous enough to source counterfeit goods is just going to create another storefront, move their stuff over, and then you're going to have to start the process all over again. So we do not want competing workflows here. We want it to all be through this litigation piece first, so that we have the element of surprise. And to Aaron's point, we have a direct channel into Amazon where we can send these things and say, hey, just push the pause button on everything so that we can get it frozen and then deal with it down the road, rather than having to chase after this sort of whack-a-mole issue. Does that answer your question?
Yeah, it does. Because I think a lot of people I want to just make sure that we're capturing all of this, because don't send it to brand registry team. I totally agree. And the next question that comes in, well, how quickly do they act? So if there's, from the time you file the temporary restraining order or the complaint for a temporary restraining order, it gets approved, then you send it immediately to them. Then how quickly does Amazon act to go freeze this?
Yeah, so in terms of sequencing, when you kick off this with the court, it's what's called an extraordinary relief, which means the court's got to deal with it quickly. So the court will typically set a preliminary hearing within a day or 2 days. We have a network of local counsel across the country who can help us. If one of us can't physically be there and the court doesn't permit Zoom attendance, we can get one of our local counsel to pop in and help, or typically courts are still doing a lot of things by Zoom at this point. Even though the pandemic's over, some of the conveniences have remained. So that will happen within a day or two, and then we send it to Amazon, and it usually happens within a day or two. We know this sort of secret sauce of how Amazon wants to receive things. So as we all know, Amazon speaks in ASINs. So we have to give a list of the ASINs and the merchant IDs and put it in a way that's very easy for them. One thing that I see that is ineffective is folks will just send over a court order and it'll say just the storefront name. Like, that's not helpful to Amazon because they don't speak in storefront, they speak in merchant ID and ASINs. So once they get the merchant ID and the ASINs, it's typically just a day or two for them to action that. If it's a lot of ASINs, that obviously takes longer. But if it's, handful, 20 ASINs, they can usually get that done in a day or two.
Awesome.
Yeah, quick.
Awesome. Yeah.
But yes, to your point, the brand registry process, I think the other big issue that we see is when folks start getting in test buys that are showing true counterfeit, the natural impulse, and I think what Amazon trains everyone to do, is just to go ahead and submit it through brand registry. Again, it'll kick out that notice to the bad guy that says suspected counterfeit. Sometimes they can save themselves by submitting false or fraudulent letters of authorization. We've seen them submit fake letters. So they'll pretend like they're the brand and they'll type up this letter and send it to Amazon and say, hey, it's not counterfeit, I got it from the brand. It's pretty brazen. We've seen some people's names used in this, where there are people who are publicly accessible to the sort of general public. We'll see those names inserted on those letters. We'll see falsified signatures, and then things that are just crazy and totally made up. So the bad guys will go to any length we've seen to try to prevent all of this from happening. So we don't want to put them on notice. Don't do the brand registry takedowns, get the lawyers involved first. And then Emma, to the next slide, please. So now we've gotten everything frozen. Where do we go from there? So we can ask the court for permission to do what's called discovery, which is when you can ask written questions, ask for documents from the bad guys and also from third parties. So we can ask the court for permission to issue subpoenas to Amazon itself for certain data related to the bad guys' sales. Amazon, is protective over consumer information and is generally, I would characterize it as territorial over the bad guys' data, but will give us things like what were the sales of what ASINs on what days, what jurisdictions were they sold into, how much did they charge, were things returned. So when we get that data, we can help use that to establish what the damages would be, meaning what does the brand show that it's out of pocket that was sold by the bad guy that could have been sold by the brand, because it's really hard to quantify what is the damage related to a counterfeit. One easy measure for that is looking at what the profits of the bad guy was. So we can get that data from Amazon. Sometimes when we're having a difficult time tracking down the bad guys and where they're located, we can ask the court for special permission to get them served via alternative means. So if you think of the traditional, like sitcoms, you see the guy pop out of the woods with the pizza box and he says, "You've been served." So that's service where you have to physically hand the documents to somebody. We have a great track record and have built up this really good case law around serving by alternative means. So we can send them the legal paperwork through email or through regular mail, or even send it through the Amazon Messenger system. And there's a lot of tricks and sometimes some machinations that need to happen to get those messages to go through the Amazon system, but we can get them served. So we'll have folks ask us, is it a problem that they have identified a US location on their storefront, but we think that they're physically located in Ukraine or China, or name another place that is outside of the United States? And the answer is typically no, because if they have identified that US location, we can use that as a basis to the court to say, hey, they identified a US location, they're not picking up their mail at that location, or it's a bad location, or it's just falsified. Court, please give us permission to serve in this alternative way. And we can go through and we can search and find out email addresses and other physical locations, or we can serve it through the Amazon Messenger. So that's sort of the concept of service of process, which can be a little bit tricky. And for those who are uninitiated in this sort of Amazon world, it can create some stumbling blocks, because folks will think, I've got to go through all these special legal challenges in order to get someone served in a foreign country. And that can be true, but we've found ways that we can avoid having to do that if we don't absolutely have to. Another thing that we want to make sure we're doing is identifying appropriate targets. So sometimes brands want to pick a fight with the biggest 10,000-pound gorilla, and sometimes brands do not want to do that. We want to make sure that we've picked out the appropriate entity, because as we know, a lot of these storefronts are interconnected and interwoven, and it can create some big issues if you're picking on somebody and you don't realize where all of those tentacles are. Somebody said, what about when the seller is located in CN, which I think is Canada? Is that an issue? It's not an issue. Oh, in China. Also not an issue. So when the seller is located in China, they're typically identifying a US address on their Amazon storefront. Canada is also not an issue. But we have found ways where typically those sellers have identified some type of a US location. If they've set up a business, that business is typically registered somewhere in the United States. And even if it's not, and they haven't identified a US location, we've still had success in getting service through alternative means, meaning we can serve them by either the messenger system or email or both or some combination. Because really the question for the court is, what is the thing that we need to do to give fair notice of the lawsuit? And the rules haven't been updated in the way that they should, in my opinion, to say email service is good. But in an e-com world where people are functioning only on e-com sites, and that's how they communicate with consumers, we've persuaded courts that it makes a lot of sense for us to be able to serve them there too. So China is not a problem. We deal with that all the time. If they are genuinely located in China, and there's not a US location, and the court is being persnickety and not letting us do this alternative service, we also have dealt with that. And there's ways that we can liaise with contacts in China to find them and get that service done. It's a pain, it takes a lot longer. But the important thing is we can still have that temporary restraining order, that pause button pushed while all of that conduct is happening so that nothing is being disrupted while we're getting them served. We can also assist with the garnishment. So unlike traditional litigation where you're on the defendant side, on the plaintiff side, you have the potential for getting some money. So a lot of these sellers have money sitting in their Amazon accounts. Last best knowledge that we have from Amazon is that it only scoops off that money once every 2 weeks. So it's a little bit of a luck of the draw when you initiate those papers to get the money seized, but we have had good luck in getting judgments of, upwards of 6 figures seized from those Amazon accounts. So it's not just a cost center, it's potentially a source of income when these litigations are run appropriately. Emma, on to the next, please. Okay, and then as we sort of alluded to before, brand registry reporting is the last step in this process. Once the cat is out of the bag and the sellers know that the lawsuit's been initiated, we can assist the brand in doing those appropriate brand registry complaints. The sequencing is so important. We don't want to tip anyone off. If you take away 2 things from this, 1, don't do bad counterfeit reporting, and 2, if you think you have a counterfeiter, don't immediately do brand registry reporting because we don't want to tip them off. So we do have a direct line to Amazon's global brand registry team. That name changes. They're calling themselves something else now. I forget what it is. It'll be something else tomorrow too. But we can help with what's the special language because there's certain words that they look for or their algorithm listens to more than others. So we want to make sure that we're doing that in the appropriate way. Emma, next slide. Okay, so that was sort of generally what is the strategy as it relates to both of these counterfeit lawsuits and the design issues that Aaron's going to talk about. So I'll kick it over to Emma, who can talk a little bit more about the scariness associated with bad counterfeit takedowns and anything else counterfeit that you would like to know.
Great, thanks, Martha. Yeah, so I'm going to dig a little deeper into what we mean by counterfeiting because it is an important word and what options there are for tackling it, litigation related, and other tools that Amazon has. And then I'll include a few examples of successes we've had for brands in counterfeiting situations that are particularly illustrative of what we're talking about, changing the facts some and speaking generally, of course, to protect the brand's confidentiality. So like Martha said, it's really important to know that counterfeit is a legal term of art. It's a product that is not manufactured by the brand. It's got a different composition or a makeup. It does not mean that the product is manufactured by the brand, but it's sold without the brand's authorization. And as Martha alluded to, we're seeing a trend of brands hiring these third-party tech vendors who advertise as being able to get sellers down really quickly and get source information. But what they're really doing is submitting counterfeiting takedown notices where there's not actual counterfeiting involved, using the word counterfeit loosely when the products are not actually counterfeit because they think it gets Amazon's attention. And it does, but usually in a bad way for the brand because Amazon does take counterfeiting on its marketplace seriously and it examines counterfeit takedown notices closely. And there's consequences for the brand for submitting false notices of counterfeiting. We've seen Amazon spend storefronts for submitting false takedowns. We've seen them require the brand to provide proof of the counterfeiting within a certain period of time or face suspension, which obviously isn't going to be proof that exists if the counterfeit takedown notice wasn't accurate. And then, as Martha was talking about, we've defended brands who have been sued by third-party sellers who were affected by what they allege was a false counterfeiting takedown notice to Amazon. And we have been told by some of those sellers' lawyers that when faced with a counterfeiting takedown, Amazon can threaten to destroy the seller's counterfeit inventory within a matter of days. And one of the ways the seller can pause that and stop Amazon from destroying all the inventory is just by suing the brand that did the takedown. These lawsuits include tortious interference, unfair competition, various state law and Lanham Act claims, including a federal claim that essentially asks the judge to say, we are not counterfeiting and our sales are not trademark infringement. And so they're not always easy to get out of. Sometimes these sellers file this lawsuit and then part of their settlement demands are the attorney's fees they've already had to expend or the sales they've lost because their storefront was improperly taken down. And so it's not always necessarily easy to just settle it and be done with it. Sometimes the sellers want more than just their storefront being put back up. So it's really important for brands to work with experienced legal counsel to help the brand investigate the counterfeiting, submit appropriate takedown notices if that's the approach they choose, or work with Amazon or litigate and proceed with the various options. The big counterfeiting issues we typically see also involve pretty sophisticated counterfeits. So we typically don't make a counterfeiting takedown notice unless we or the brand have done an investigation proving that the product is counterfeit, like a composition analysis, sending the product to the lab to test the ingredients, taking the product apart and examining its components, examining the packaging closely for different markings or misspellings on the bottle, things like that to have proof of counterfeiting before we even go to Amazon. And we've had multiple clients come to us after using a tech vendor that did this brand registry thing wrong. And we know how to manage the ins and outs when that does happen. But we also know how to help the brand tackle counterfeiting from the beginning in a way that works within their overall online strategy and doesn't expose them to that legal risk. And so one of the things that we routinely do is work with Amazon's Counterfeit Crimes Unit, or CCU. And we'll work with a brand and provide Amazon with relevant information about the counterfeiting situation, like the storefronts that are counterfeiting, information about test buys that the brand has already done, takedown notices the brand has already submitted, results from lab composition analyses proving that the products are counterfeit. We'll send all of that to Amazon, and then Amazon, as Martha said, has access to a lot of data that it's pretty protective of, but the CCU has access to it too, and in counterfeiting situations can use its resources to see data sort of behind the storefronts. So for example, they can see where products are coming from when they're shipped into Amazon's warehouses to be fulfilled by Amazon. So even though the information on the storefront is more than likely false, the information with the return address that a product was shipped to the warehouse from is generally going to have to be accurate. Amazon can also see where the seller has designated that product returns should go. Amazon can also see IP address login stamps for sellers, and it can work with its connections with law enforcement locally and abroad for even further data collection. And so when brands are working with the CCU, depending on the situation, there's a couple of different options. In some situations, Amazon might want to pair with the brand and file a public lawsuit against the counterfeiters. This is at no cost to the brand, and frankly is good publicity for Amazon to show the public and governing bodies that it is policing counterfeits on its marketplace. This option can, though, potentially create publicity for the brand about its counterfeiting problem that it may not want out there. And so we can help brands analyze the risk of potential press, work on public messaging, and make a determination on how helpful or harmful this option might be within the brand's overall strategy. Another option, sometimes Amazon will want to do a joint criminal referral with the brand. And that means that Amazon and the brand, with our help, will jointly package investigative information to give to the appropriate authorities to get counterfeiters prosecuted criminally. This is also no cost to the brand, and it avoids potential big press headlines, as the criminal indictments are typically sealed. Even if they're not sealed, brand names are typically used discreetly, referred to as like Company A instead of the brand's name. But the counterfeiting issue typically needs to be pretty significant in scope or in consumer harm for Amazon to commit its resources in this way. And so we can talk through this option with the brand and with Amazon and the CCU. Another thing we can help brands accomplish for a longer term strategy to tackle counterfeiting is brand gating. And it's a little harder to get now than it was in the earlier days of the Amazon marketplace. But brand gating requires 3P sellers of a brand's product to apply and fulfill certain criteria to be allowed to sell the products. In other words, proof that they're allowed to sell. And brands have to be enrolled in brand registry and provide pretty specific information to Amazon for Amazon to even consider gating the brands. That's why this is another area where it's helpful to have counsel involved to provide the information to Amazon and convey to Amazon, convince it that these products need to be gated. There's a big counterfeiting issue. It's an important counterfeiting issue. And we know from experience that the two key considerations for Amazon on whether it wants to gate a brand's products are evidence of the scope of the counterfeiting problem. So either the number of products or the number of ASINs that are affected, how much money consumers are spending on these products, how many consumers have bought counterfeit products, which is all data that Amazon has, and also the level of risk to consumer health and safety based on the type of product. Brand gating is not a quick or a guaranteed process in our experience. It's often at the whim of Amazon, but we have seen that doing things like test buys, lab analyses, getting the CCU involved, having the evidence of counterfeiting, showing that the brand is also taking efforts to protect itself from counterfeiting can help Amazon take the step of helping out and gating the products. A related option that I'll touch on briefly is Amazon's transparency program, which brands have to enroll in and meet certain requirements again. And it involves transparency codes being stamped on all authentic products so that only those stamped products are even listed and shipped by Amazon. And this can be really helpful to some brands, but it also depends on the scope of the issue because it works on an ASIN by ASIN basis. So if there's a lot of impacted various ASINs, it can be a little voluminous to manage. Vorys eControl also has experience enforcing against counterfeiters who are not selling on Amazon, and we can work with the Customs and Border Patrol or work with local authorities to get products seized if the brand knows the location of the warehouse where the products are being stored. We see a lot of counterfeiting on Amazon, but obviously there's some off, so we can address a brand's needs there too. So I want to talk about a few examples that I think helpfully touch on what Martha's talked about today, what I talked a little bit about. Obviously not the the ones shown in the pictures, of course. The first one is a seasonal topical product brand. So this brand creates seasonal topical products with specific formulations for safety, and it discovered vast amounts of counterfeit products being sold on Amazon during its peak season. And so it considered the two avenues that Martha talked about, litigation, filing the lawsuit, seeking a temporary restraining order, doing alternative service, freezing the accounts to get the money out of them. It also considered submitting brand registry takedown notices. And that worked, but because it was coupled with other efforts. So the brand ultimately was submitting brand registry takedown notices. And even though that did sort of communicate the problem to the sellers, Vorys also worked with its contacts within the CCU to get Amazon's attention and sort of rein it in. And as a result, with the help of the CCU, the storefronts that were selling the counterfeit products were removed by Amazon, as were new storefronts that kept popping up because the sellers would pick up their operation and move it to another storefront. Amazon was removing those newly discovered storefronts as well. And because of the incredible volume of counterfeit products, Amazon and the brand agreed to do a joint criminal investigation into the counterfeiters and compiled all of that information. Interestingly, Amazon for this brand also agreed to remove all customer reviews that were affiliated with the counterfeiters, which is a big boon to the brand's reputation on Amazon. So there's different considerations for each approach. This worked out. It was effective and pretty low key, but Amazon froze the money in the counterfeiters' accounts to contribute toward refunds to customers who had bought the counterfeit products. Without litigation and a court order, the brand couldn't demand entitlement to the revenues in those accounts, but it did get the storefronts down. Another brand who's dealt with this is a really interesting supplement product, and they create supplements formulated specifically without certain allergens and ingredients. And this brand diligently conducted test buys from unauthorized storefronts and discovered that the products were counterfeit. They appeared to be being manufactured in another country, and they contained all of the allergens and ingredients that this brand had banned from its products. It sent these test buys to a lab, and it got a full report of the ingredients and the allergens and everything that was contained in those supplements. With Vorys' help investigating these sellers, it also discovered a link among several of the storefronts that were all selling the same kind of counterfeit products, and it filed a counterfeiting lawsuit against those defendants. And through those defendants, it obtained discovery about other actors in the scheme that sort of allowed the brand to, form like a link chain to the main source of the counterfeiting and initiate investigation abroad. Simultaneously with this lawsuit, we were working with our contacts at the CCU, which helped the brand begin to identify the potential identities and location of the counterfeiters in the foreign country. And all the while, the other litigation options remained open to the brand if it wanted to take that route. Because this brand was persistent and because this brand had excellent proof of test buys and counterfeiting, and through its work with the CCU, during the course of this, Amazon did grant the brand's request for gating after some months, and that helped a lot to getting those storefronts automatically down. The last one I'll talk about real quickly so we can move on to Aaron. Martha sort of alluded to the unfortunate situation that this brand found itself in that it submitted takedown notices, but Amazon gave the affected sellers a 14-day window to appeal. So the takedown notices were proper. There was proof of the counterfeiting. Amazon accepted them, but it gave the sellers 14 days to provide an invoice authenticating the product. And of course, the invoices were fake, or in some cases, Amazon will authenticate the invoices on a virtual interview, and someone will hold up a piece of paper showing the authenticating invoice. And regardless of whether Amazon accepts that or not, during this 14-day appeal window, the listing remains up. So customers were able to continue to buy these products. Eventually, this brand's persistence and its combined efforts of working with the CCU and submitting these takedowns paid off, and Amazon also was able to gate this brand's products, which was a big success. So with that, I will turn it over to Aaron to talk a little bit how counterfeiting works in the design patent context.
Yes, and Aaron, we might end up having a follow-up one as well, because maybe we can cover it in 5 to 7 minutes here. Let's give it a whirl.
I'm gonna give it a whirl.
Sorry, Aaron.
Hey, no, this is the reality is it's very complicated, and you have to be thorough. You have to be thorough because there's so much at stake if you're not. If you do yank them down, you don't do it all, and it's the wrong thing to do, you lose money. And if you do it, and then for some reason you're not thorough, then they don't get taken down. So anyways, I'll jump. Aaron, to you.
All right, Emma, if you go to the next slide, I'll cover this pretty quick, high level, and then to Aaron's point, if we need a follow-up with some more detail, happy to do that and provide some additional context. But a lot of what we've been talking about today, brands have, 1, 2 products that are giving them problems. But what happens when there's 20, 50, 100 players out there that have products that are either violating your trademark rights or patent rights? Over the last 3 years, really since about the second quarter into COVID, there's been a large scale movement towards these en masse litigations against foreign e-commerce sellers in district courts in the United States. In both trademark and patent, we're seeing, litigations involving 50, 100, upwards of 250 defendants. And it's a way and a tool that brands can use, basically taking all of these enforcement mechanisms that we've been talking about today and applying them on a large scale, filing 1 complaint, 1 temporary restraining order, 1 motion for preliminary injunction, and getting 1 judgment against 200 plus sellers in a span of about 4 months. It's a tool that we've been looking at and following, and there's different ways to handle it, but it follows a lot of the same steps and investigative patterns that Martha highlighted early on. Test buys, doing them properly, making sure that you know which jurisdictions you're looking at and which jurisdictions are friendly to these type of procedures. They're unique. And so being in a jurisdiction that has familiarity with them and familiarity with the types of requests that are required is paramount in these cases. And so working with counsel that is familiar with them, knows how to handle them, is of the utmost importance. And so going to the next slide, I'm going to talk about one area of brand enforcement strategy that people don't typically think of, which is patent protection. And when you mention patents to people, eyes roll into the back of your head. You start thinking about, technical issues and science degrees and things that most of us ran away from in high school and college. But design patents are specifically geared to protect the aesthetic appearance of goods, right? They cover the aesthetic non-functional aspects of a particular good. And so if you're rolling out a new product, it's important to think about, do I want to rely on trademark rights, or do I want to guarantee that I have a monopoly over the way this product looks for the next 15 years? Because that's what a design patent gives you. And so it allows brands to really control the marketplace, especially if you have a really new inventive concept for a good. Design patents cover everything from doors to consumer electronics and everything in between. One of the best examples I like to give people is Crocs, right? Clogs have been around forever, but Crocs came out with a new interesting way to manufacture a clog that people would wear. Whether you consider them fashionable or not is up to you, but they patented it. They patented the design of their clog and were able to use that patent and monopoly right over that design to keep others out of the marketplace and trying to pull market share from them and their new design. And so it's something to think about as you're putting together your brand strategy. If you're coming out with a new product and you want to make sure that others in the marketplace can't take away from your inventive thoughts, and you want to protect that market share that you're hoping to develop. And so infringement's pretty easy. It's not like other patents. You do a side-by-side comparison of the drawings in the patent with the accused product, and you decide whether or not an ordinary person would be able to determine that one is different than the other. So it's a pretty straightforward process, something that we can help with both on the front end and on the back end, and would happy to talk with people more about how to use these strategies to help with their brand enforcement efforts.
Yeah, really quick, we have a question that came in. We've seen a company called Amazon Exports LLC hijacking our obsolete ASINs and selling products that have been discontinued, right? So initially thought this was part of Amazon, but it's not. Try to do brand registry, but people internally think it might be part of Amazon, so they're not pulling it down. Like, is this something you would help with? Like, help pull down if they're selling obsolete old ASINs that aren't being manufactured? And I think if you have this in place, a design patent, it'd be pretty straightforward, but
if you had a design patent in place and they were taking the ASINs and selling using the ASINs to sell their product that looks, identical to yours, then yeah, that would be in place. I'm not familiar with the process of buying the old ASINs and selling them. I don't know if Martha's come across that question with clients before or not.
Yeah. Yeah, so just real quickly, I would guess it's not Amazon is confused. I would guess it's Amazon doesn't care, probably because the appropriate language hasn't been popped into that brand registry report. So there's certain language that they care about and like to see. We can help develop that language, but I would guess that it's not confusion. Although I do think Amazon's intentionally siloed. I think in this case, they know, and you haven't said the right words yet.
Awesome. Well, any key takeaways here as we kind of wrap up? We're going to push up right against the hour, or did we have a follow-up one, or that we go a deep dive on this design patent? So maybe it's only 30 minutes, but I see here, like, I totally agree. It's got to be the fastest growing segment of e-commerce enforcement, because everybody's got to be thinking about doing this. But anyways, quick, any key takeaways, Martha? And more than happy to connect everybody with the Vorys team here after the call.
Well, I think the key takeaway is don't let me talk first, because I'm going to talk the whole time. The other key takeaways are just to be super careful when you're doing this. Make sure you're vetting your counsel. It's easier to go at it fresh than to try to come back in and clean up mistakes that other people have done. Even if it's not us, you're looking for lawyers, make sure that there's somebody who has know-how in this specific field rather than just sort of a general litigator. So that's probably the most important thing that I would give as my key takeaway.
Awesome. Well, everybody, we'll get a recording of this out. Thanks everybody for dialing in. The questions that came in, yes, a couple people love to follow up on design patents enforcement, 100%. And sorry we didn't get to the GS1. More than happy to connect you with the Vorys team after the call. But this we got to wrap up as we push up right against time. Look for a follow-up email from me. I'd love to connect with everybody on the line today, and more than happy to connect you with everybody over at the Vorys team, the great friends, partners, supporters of the network. With that, can we get a copy of the deck? Are we able to send that out, team? If we can, we'll send it out.
Email us. I'm afraid
Okay.
it's not very much content, but yeah, we have other things we can send you that are probably better.
Awesome. Well, with that, we're going to wrap up. Thanks again, everybody, for joining. Everybody take care, stay safe, and look forward to having you at a future event. All right. See ya. Bye-bye.